appeal in the matter of the King on the application of Boswell and the Secretary of State for Transport and
Yes, Mr. Wolf.
Good morning, my lords. As you will have seen, Mr. Peter Lockley, Ben Mitchell and I appear on behalf of Dr. Andrew Boswell, the appellant in this matter. Rose Grogan, James Strawn appear on behalf of the Secretary of State for Transport, the first respondent, and Reuben Taylor on behalf of the second respondent, National Highways.
Thank you.
You should, I hope, for the purposes of this appeal, have three bundles: a core bundle, a supplementary bundle, and a combined legal materials bundle. You will have seen that this is an appeal pursuant to permission granted by Lord Justice Coulson in relation to a single order following a single judgment dealing with 3 judicial review hearings, each of which dealt with a development consent order decision made by the Secretary of State, albeit by 3 separate ministers, in relation to 3 road schemes, all of which have been described as part of the A47 improvement programme. I'll come back to that in due course. What I'd like to do, if I may, is to start by introducing the courts to the legal context for these appeal. And I'd do that, if I may, by asking the court to pick up the legal materials bundle and going to the Climate Change Act, which you have in tab 2 of that bundle. We have 2 main pieces of legislation in play here: the Climate Change Act and the Planning Act, both 2008, introduced by Parliament quick succession. Climate Change Act you have core extracts from, and then I'm going to take the court in a few moments to a judgment of Mr. Justice Holgate where he describes its mechanics in a little bit more detail, if I may. So, the Climate Change Act, the main overarching proposition in the Climate Change Act, and you have this tab 2, page 15, is section 1 of the Climate Change Act. As you'll see when I take you to Mr. Justice Holgate's judgment, this is part of the UK's response to the Paris Agreement, which in turn is the international response to the global threat of climate change. And the overarching obligation in the Climate Change Act itself, section 1.1 of the Act, specifies that it is the duty of the Secretary of State to ensure that the net UK carbon account for the year 2050 is at least 100% lower than the 1990 baseline. That 100% figure, I'll explain to you in a moment, was introduced by amendment in 2019. So what we have here is the overarching statutory target obligation on effectively the government to bring the UK into what's colloquially known as net zero by 2050. Obviously, a great deal needs to happen to secure that. The Climate Change Act itself has some mechanisms in it to assist on that process, and they are primarily set out, this is pages 16 and 17, in carbon budgets. So on the way to net zero, it's not simply a point to be reached by 2050, there are steps along the way. Section 4 and 8 you have in the bundle provide for carbon budgets, which are 5-yearly, and the word budget is important, that they are levels of effectively greenhouse gas emissions that have to be achieved within those periods. And as you'll see, this is all on the downward path to net zero by 2050. So section 4.1, page 16 of the bundle, it's the duty of the Secretary of State to set for each succeeding period of 5 years, beginning in the period of 2008 to 2012, an amount for the net UK carbon account, the carbon budget, that's the setting, and then the obligation to ensure that the net UK carbon account for the budgetary period does not exceed the carbon budget. So that's in a 5-yearly period, those are the steps along the way. Section 8 tells us that the Secretary of State must set the carbon budget by order, but with a view to securing the target by 2050. So each of these 5-yearly periods is on a downward path to zero by 2050. The important thing about the carbon budgets within that framework is there is no mechanism within this to actually secure any of these things. This is simply the target to be achieved. This was described by Mr. Justice Holgate, as I indicated, in a case which the court has in the bundle at tab 14. This was a challenge to the government's, what was called its net zero strategy, the government's overall set of policies and proposals for securing the next steps on the way to net zero. The result of which, not part of the case here, the result of which was that the net zero strategy was declared to be unlawful. What I want to show the court, if I may, is at page 432 and following, which is the judge's introduction to the regime which you've just seen a flavour of in the statutory materials. So the first few paragraphs of the judgment, I won't take the court through them in full detail, they're there for reference. And paragraphs 1 and 2 on page 432 explain the context of climate change overall and the Paris Agreement, an international agreement produced in 2015. Paragraph 3 of the judgment sets out some of the mechanics of the Paris Agreement. Paragraph 5 then picks up what the judge calls the UK response to the Paris Agreement, part of which, as you've seen, is the Climate Change Act, requirement within that to reach net zero by 2050, the 100% lower of anything is net zero. And importantly, in one sense, paragraph 6 of the judgment, according to the net zero strategy, the UK currently accounts for less than 1% of global greenhouse gas emissions. The relevance of that is that, quite as consensus common knowledge, climate change is an international problem which requires an international response. And each country within the Paris Agreement is being asked to make a contribution to that. And within that, and we then have a framework which moderates how the UK makes its contribution. But the simple point, the simple overarching point, is that meeting net zero globally and net zero within our legal framework, every individual, every organisation, government and so on, this is necessarily the cumulative response to all of our individual actions. Paragraph 7 and following then explain the mechanics, as I've introduced them, of the climate budgets, the carbon budgets, and you have in paragraph 8 a brief introduction to how those things are calculated. Paragraph 10 is then important because that explains to the reader what numerically the carbon budgets that have been set so far come to. We've so far got carbon budgets 1 to 6 set, and they, if you look at the right-hand column in that table there, they show us a percentage reduction from the 1990 level, going from 25, 31, 41, 55, 60, down to 78%. So what we see, and we can position ourselves within the 4th carbon budget, is that we are on the way to reaching net zero, but there is more work to be done. And within the 6th carbon budget, which is the furthest away currently set, that requires a 78% reduction. And importantly, Mr. Justice Holgate explains then in paragraphs 11 and 12, he explains the way in which the 4th and 5th carbon budgets have been exceeded, but that's in part because they were set by reference to an earlier ambition. Carbon budget 6 is the first one to be set by reference to the 100% target, and as he puts it, it's common ground that the target in CB6 is substantially more challenging than those that previously were set. Relevance of that is that we have to meet each of those carbon budgets along the way, and it is getting harder as we approach net zero. To stand back from that for a moment, as I indicated, whether or not the UK reaches those targets, whether or not the Secretary of State therefore overall achieves the objectives, is a product of everybody's actions. And some of those actions will be government actions, some of them will be citizens' actions. In relation to the government actions, there are a number of different tools and levers that the government, of course, has. It can allow things to happen, it can stop things to happen. Importantly, though, within that, there are some things, and what the court is dealing with today is an example of that, that are one-offs. This is a decision that we're dealing with here to allow the building of a road scheme. Not something that can be turned on and off like other sorts of behaviours. So the issue then is, how do we deal with the carbon impacts, the climate change impacts, when the decision is made to allow or not allow whether to proceed with the road schemes? And that's the issue that was in play in these development consent orders and is in play in these proceedings. The legal framework, just to move to the other legislation that we need to deal with for this appeal, the legal framework that regulates that is the Planning Act of 2008, passed shortly after the Climate Change Act, clearly entirely cognizant of it. You have that in tab 1 of your legal materials bundle. This is in effect the planning regime for big projects, the planning regime for what are called national significant infrastructure projects. So in some senses it tracks the planning regime for smaller projects, but it has some particular other characteristics. Again, I'm only going to show you the highlights of it, and there's a bit more of an explanation of it in a decision of the Supreme Court, which I'm going to show you in a few moments. Part of the context for the National Significant Infrastructure Project regime is what are called national policy statements. And you have section 5 you have the introduction of the regime for national policy statements. So these are elements of government policy that provide, and I use the word advisedly, the framework within which, in accordance with which, decisions on individual projects are made. But the national policy statements don't decide the answer. The answer for each scheme is still an individual scheme decision, as you'll see in a moment. In terms of what fits within the Planning Act regime, section 14 you have at page 5 of your bundle. That gives you an overarching list of the schemes which fit within this regime, so-called national significant infrastructure projects, one of which is section 14(1)(h), highway-related development, and then at section 22, there's a further breakdown of what kinds of highway developments fall within this regime, and it's only, in broad terms, the more significant infrastructure projects that fit within the NSIP regime. For all of them, and this is section 31 on page 11, development consent is required. Section 31 says this: consent under this Act, quotes, development consent is required for development to the extent that development is or forms part of a national significant infrastructure project. So these road schemes cannot go ahead, and will only go ahead if they receive development consent, effectively the NSIP equivalent of planning permission. In those cases, and you have this at page 12 and elsewhere, page 12 sets out section 104 of the Planning Act. 104.1, this section applies in relation to any application for an order granting development consent if a national policy statement has effect, and that's the situation here. 104.2, in deciding the application, the Secretary of State must have regard to the national policy statement. 104.3, further down the page, the Secretary of State must decide an application in accordance with any relevant national policy statement. 104.7, on the right-hand page, this subsection applies if the Secretary of State is satisfied the adverse impact of proposed development outweighs the benefits. So there are a series of statutory requirements around this decision, but none of those preclude an assessment of and an evaluation of what you might call the pros and cons, the impacts and benefits of the proposal in question. That regime was described by the Supreme Court in a judgment that the Court has at tab 11, Friends of the Earth and Secretary of State, dealing with Heathrow Airport. Within that, you have a long sideline section starting at page 295, which describes, outlines that NSIP regime, introduced, as the Supreme Court explains, in order to streamline in overall procedural terms the process for dealing with national significant infrastructure projects, following an era in which there had been long and time-consuming and so on planning inquiries. This was intended to streamline that regime, but not in any sense to short-circuit the decision-making. Within that long section, you see, if I can pick it up in my May at paragraph 31 on page 298, having described the NPS process, Lord Hodge and Lord Sales say this: an NPS is not the end of the process, it simply sets the policy framework within which any application for DCO must be determined, etc., and explains that. So none of this precludes the specific decision-making framework. Then at paragraph 34 of the judgment, you see a description. You haven't in the bundle got the description of the mechanics of this in the statute itself, but you see the description of a process of appointing what is called an examining authority. That can be an individual or a panel who, a bit like a planning inspector in the ordinary planning regime, go through a process called here an examination, at the end of which they produce a report called an examination report, which is then considered by the Secretary of State. All of that is part of the statutory framework, and that is what you'll see in play here. In terms of the specifics of some of what goes on in that process, you then have, if I may, the environmental impact assessment element of that. You have this in tab 3, so part of the scheme-specific consideration within that process framework is what is called environmental impact assessment. Importantly, let me just introduce one important concept and then get into the detail. Environmental impact assessment is a process, and you'll see that described in the regulations in a moment. It is a process within which one has an environmental statement. Sometimes lazily, perhaps not lazily, but inadvertently, people refer to EIA when they mean environmental statement. And I'll show you this in a second. Environmental statement is a document produced by the applicant for development consent. It may or may not, you'll see what I mean by this in a moment, cover all the aspects. It is only one part of the overall process of environmental impact assessment. What is mandatory, and I'll show you this in a second, is the process of environmental impact assessment. Let me make all of that good. Introduction to this is Regulation 4, page 22 of your bundle. You have the prohibition on granting consent without consideration of environmental information. The heading is a little bit incomplete, if I can put it that way, because it actually refers to more than consideration of the environmental information. It refers to the the EIA process. I can ask the court to look at Regulation 4.1. This regulation applies to applications for an order granting development consent for EIA development received by the Secretary of State. So this is the situation where, as here, the Secretary of State has received 1, or in this case 3, applications for development consent. 4.2, where this regulation applies, the Secretary of State or relevant authority must not make an order granting development consent, grant subsequent consent, unless an EIA has been carried out in respect of the application. An EIA has been carried out in respect of the application. And that's the process. We see that illuminated at Regulation 5. You have this on page 23. The environmental impact assessment, the EIA, is a process consisting of 3 steps. The preparation of an environmental statement by the applicant, the carrying out of consultation under these regulations or otherwise, and then thirdly, the steps that are required to be undertaken by the Secretary of State under Regulation 21, etc. And I'll come to Regulation 21 in a moment, because that, again, is part of the process. So we have a process comprising 5.1a and b, and then in this case 21, which is itself a further process. So a series of steps in sequence. Within that, you've seen the reference to environmental statement. Can I just show you then the definitions in Regulation 3? Go back, if you would, please, to page 19 of the bundle. You have here some concepts that we need to carry forward. In the interpretation section, towards the foot of page 19, the very foot of the page, the last entry, environmental statement has the meaning given by Regulation 14. And then, importantly, the definition above that, environmental information means the environmental statement, ... including any other further information, any representations made by anybody required by this regulation to be valid representations, and by other persons about the environmental effects. So environmental statement is the document produced by the applicant, the developer. Environmental information is that plus, amongst other things, the public consultation responses. That matters when we come back to, or when we then go to the provisions which I'll go to in a few moments, as the requirements on the Secretary of State to consider the environmental information. Because what they are looking at is the environmental statement plus, amongst other things, the consultation responses. Before I do that, that's Regulation 21, can I ask the court to look at the elements which go into the environmental statement, because that's the developer's document. So, environmental statement, we saw the Regulation 3 entry, that takes us to Regulation 14, that's on page 25 of your bundle. Regulation 14, an application for an order granting development consent for EIA development, that's where we are, must be accompanied by an environmental statement. An environmental statement is a statement which includes at least, so it's a minimum, it can include more, and then the things to be included in each case are a description. That words are important. So first of all, 14.2a, a description of the development, and then 14.2b, a description of the likely significant effects of the proposed development on the environment. So there may be many effects of a development on the environment: noise, pollution, traffic, all sorts of things. impacts on wildlife, whatever it may be, what the ES has to do is provide a description of those things. And then links into any additional information specified in Schedule 4, that's 14.2f. That is all informing, if I can just take you back, sorry if I'm taking it slightly out of order, to Regulation 5, the environmental impact assessment process. What we are trying to achieve here through the process, this is back to Regulation 5.2, Regulation 5.2, identify, describe and assess in an appropriate manner, in the light of each individual case, the direct and significant effects of the proposed development on the following factors. And then there are a series of factors: population and human health, 5.2a, biodiversity, 5.2b, land, water, soil, air and climate, 5.2c. So the EIA process is setting out to describe and assess, two separate things, describe and assess, amongst other things, the impact of the development on climate. And the ES, see Regulation 14, is at a minimum providing the description distinct from assessment. So we immediately see that amongst other things, this regime is completely cognizant that one of the potential impacts of a development may well be impacts on climate. And also in 5.3, the effects referred to in paragraph 2 on the factors set out in that paragraph must include the operational effects of a proposed development. So we're not simply concerned, as it were, with the impact of laying the tarmac for a road scheme. We're concerned with the operational impacts. And in the context of a road scheme, as we have here, that is acknowledged to be the impacts of the increase in traffic which is enabled or facilitated by the road scheme. So immediately we see that the environmental statement, not only is that not the end of the process, but it's got to provide, amongst other things, a description of the likely significant effects of the development, including on climate, including from the additional road traffic. All so far, I think, entirely uncontroversial. Regulation 14 took us into, as part of the information potentially to be included in the environmental statement, Schedule 4. You have Schedule 4 starting at page 27, if I may. Each paragraph of the schedule has been perhaps slightly unhelpfully printed on a different page, but all of these are the paragraphs, of Schedule 4. Schedule 4, Para 1, sets out the requirement for a description of the development, including, this is 1D, an estimate by type and quantity of expected residues and emissions, such as water, oil and subsoil, noise, vibration, etc. So that's part of the description. Paragraph 4, this is on page 30, requires a description of the factors likely to be significantly affected, one of which, if we read down to the third line towards the end, is climate. So we are looking to see what is significantly affected, and that can include climate, and does here. And then paragraph 5 on page 31, again using the word description of the effects of the development, so prior stage to assessment, a description of the likely significant effects of development on the environment resulting from, amongst other things, and then construction existence of the development, 2, the use of natural resources, 3, the emission of pollutants, 4, the risk to human health, jumping over E for the moment, F, the impact of the project on climate. So we again see that in each case, a wide range of sources of impact, which include effect on climate, and a wide set area, go back to paragraph 4, of the factors that can be impacted, again, including climate. And then within that same list, paragraph E, 5E, this is where it gets close to the nub of the case here, the cumulation of effects, and that's capable of being any of those effects, with other existing and or approved projects, taking into account any existing environmental problems related to areas of particular environmental importance likely to be affected by or the use of natural resources. So just to step back again to look at paragraph 5, looking forward, what paragraph 5 is requiring is a description of the likely significant effects of the development, and the significant effects of the development include the cumulation of effects with other existing or approved projects. So those are identified as a matter of statutory construction as part of the impacts of the development. You do not look at the development simply on its own. You are looking to describe, and in due course we'll see, assess, as part of the impacts of the development, the cumulation of effects with other existing or approved projects. That concept is reinforced when we look at the text below the subparagraphs, which says this: description of the likely significant effects on the factors specified in Regulation 5.2, which the court will recall included climate, should cover the direct effects and any indirect, secondary, cumulative, transboundary, etc. effects of the development. So reinforcing that the description needs to include the cumulative effects of the development by reference to, amongst other things, climate, as if that wasn't perhaps already clear enough from the opening part of Regulation 5. So that's the environmental statement. The public, amongst others, can then comment on that. That produces the environmental information. That then takes us in, if I may, to Regulation 21, which you have on page 26. So the court will recall this is the extended element of the process that was provided for by Regulation 5. The Regulation 5, prepare the ES, carry out the consultation, and then that takes us into Regulation 21. Regulation 21 says this, and this is the nub of the development consent question. When deciding whether to make an order granting development consent, so that directly feeds into the Section 31 of the Planning Act question, whether we make the development consent order, feeds into the Section 104 of the Planning Act question that the court's already seen. When deciding whether to make the order granting development consent, the Secretary of State must examine the environmental information. Environmental information, as the court will recall, is the ES plus the consultation responses. Examine the environmental information. So have a look at the material which provides the description of the various impacts. And then 21B, reach a reasoned conclusion on the significant effects of the proposed development on the environment, take into account the examination referred to in subparagraph A and potentially other things. So a reasoned conclusion on the significant effects of development, take into account examination of the information. It's a separate step in the process. And then C, integrate that conclusion into the decision as to whether an order is to be granted. So the Secretary of State, or in this instance the Minister, has to look at the information provided by the developer, look at the information provided by consultees, that's the environmental information, reach a conclusion on the significance of those impacts, and feed that into the decision as to whether or not to make the order. And all of that brings forward the incumulation or cumulative impacts, including by reference to climate change. And as you'll see, and the judge makes this very clear, and it's not a subject of appeal, it was acknowledged here that in each of these instances there needed to be a cumulative assessment of the developments by reference to their climate change impacts. Not a controversial proposition, but you now see, I hope, from the mechanics of how that looks, where that all comes from. So the issue then is cumulative impact feeding into the development to make the decision to make development consent. The court has a number of cases in front of it, which I'm not going to labour. I just want to refer to a couple of those, if I may. None of them deal directly with the situation with which we're concerned.
Could I just check that I've understood correctly? So the cumulative effects concept comes into the regulations at the stage of the environmental statement and is brought in at that point.
Yes.
And that environmental statement then forms part of the materials which must be considered under Regulation 21.
Exactly. Along environmental statement plus public consultation responses.
Of course, with everything.
Everything comes in at that point.
Is then brought in.
Exactly right.
But the concept of the cumulative effect, which is what this appeal is really about, have I understood correctly, repeat myself, comes in at the stage of the materials that go to the Secretary of State, rather than in the description of the process of the
yes, although
of consideration.
Indeed, my lord, the process, that's correct. The process is important though, because
I don't say it isn't, but I just it isn't a situation where we're considering something which describes the process of consideration and includes cumulative effects. It's to be taken, you would no doubt argue, that reaching a reasoned conclusion involves taking account of the fact that cumulative effects must be regarded.
Exactly right. And I'll come in a moment to the second and third stage of that, the assessment and the reasoned conclusion and the whether to question. It's not simply about what we've called enumeration. The word in the regulations is description. In other words, here's a number. Here's a number tells you nothing in one sense. You've got to have a context of the number. And what the Secretary of State did, and we don't complain about this, and you'll see why in a moment, is to put the number enumerated or put numbers into the context of national carbon budgets. We don't complain about that general principle. The question is what they fed into that evaluation. Because a number on its own is simply tells you nothing about whether you should permit the development or not. It's all about contextualising or a threshold or a target figure, whatever it may be, whatever language you want to use. But yet, the important point I think answers your question, Imol's question, is that the ES, all it actually needs to do is describe the initial point, which is the impact. That's not necessarily an assessment of the impact in the context of what's an acceptable threshold. Did my lord have a question?
Yeah. Have I also got it right that the assessment of the significance comes in, as it were, after you've done the accumulation rather than before? Yeah. In a sense, it's not only individually significant items which have to be accumulated. Rather, you have to look at all accumulating effects which have been selected for the purpose of comparison.
Yes, yes. And
then address the question of significance after rather than before you've done that.
Exactly. That's exactly right. That's certainly our case. What you might say, the element of greyness in this is that as I've shown the court, the regulations only require the environmental statement to provide a description of the impacts. It doesn't actually require the environmental statement to do the second bit, which is the contextualising bit, the assessment of significance. But as you'll see, albeit we say in an incomplete way, these environmental statements did a bit of the latter, and that's normal practice. That's normal practice. But strictly speaking, what the ES is required to do is to describe the effects, and that's step one of the process. But either way round, by the time you get to the decision maker, Regulation 21 is bringing all that together. My lord, the two cases I was not going to just indicate to the court, one of which is a case called Blewett, which you have in tab 4. Everything in here was subsequently picked up and approved by the Supreme Court in Heathrow, but I'll just show it to you in the original for the moment, if I may. Blewett is in tab 4. This contained a situation in which the environmental statement in and of itself was being complained of. What you'll see, as I'll show you the court in a second, was it was said you can't grant planning permission, as it was there, with an environmental statement that leaves things to be assessed later. That was the gist of the problem there. It was a pushing it down to later problem in relation to elements of the environmental statement. And what Mr. Justice, as he was then, Sullivan was concerned with was therefore a criticism of the environmental statement. Now, the sideline passages, let me just pick those up fairly swiftly. Page 47, paragraphs 31 to 33. You see the leftover point at the end of paragraph 31. In summary, this is the last two lines of 31. The assessment of likely impacts and description of the necessary mitigation measures were left over for subsequent determination. That was the complaint. That was the underlying substantive complaint. Then paragraph 32 sets out in the different regulations that were in play there, but the principles are the same, what was needed into an environmental statement. And 33 says this: the local planning authority decision is of course subject to review on normal Wensbury principles. And this is the thrust of this case. It's for the local authority, or here the Secretary of State, to decide whether the ES is sufficient. But the important point, and this was why the challenge failed in that case, an ES can have gaps in it. An ES doesn't need to cover all the ground, and that's the thrust of where we go now. Paragraphs 38 and 39, Mr. Justice Sullivan describes the environmental statement, sets out the provisions in play there, which are essentially similar to the provisions in play here. Paragraph 41, though, ground 1 in these proceedings is an example of the unduly legalistic approach to the requirements of Schedule 4 to the regulations that have been adopted on behalf of claimants in a number of applications for judicial review, seeking to prevent the implementation of development proposals. the regulation should be interpreted as a whole in a common sense way. The requirement that an EIA application must be accompanied by an environmental statement is not intended to obstruct such development. The purpose is to ensure that planning decisions which may affect the environment are made on the basis of, quotes, full information. That comes from Lord Hoffman in Brown. In an imperfect world, it's an unrealistic counsel of perfection to expect that an applicant's environmental statement will always contain the full information about the environmental impact of the project. The regulations are not based upon such an unrealistic expectation. They recognise that an environmental statement may well be deficient and make provision through the publicity and consultation process for any deficiencies to be identified, and the resulting environmental information provides local authority with as full a picture as possible. In other words, and you see this picked up again in the closing summary of this section of paragraph 68 on page 63, don't bring a challenge to the grant of planning permission because there are gaps in the ES. And just to be very clear, that is not our case is not simply because there are gaps in the ES, these development consents are not lawful. What matters is the ES plus the consultation responses, and here, what the Secretary of State did with all of that. Because the point was, gaps or no gaps in the ES, the resulting decision had to fit the requirements here of regulations 5 and 21, which provide the overall process. So the fact that, or the legal proposition that it's a Wensbury question as to whether the ES is complete is not an issue here. It's not an issue here. We're not making that freestanding criticism. We simply say there was a failure to comply with the legal requirements arising from regulations 5 and 21. As I say, those passages are picked up, just for the court's note, in the Heathrow judgment. You have this in tab. I took you there because it's a classic formulation that then propagates through other cases, but recently picked up by the Supreme Court in the Heathrow litigation. That's tab 11, around paragraphs 142 to 144. I won't take time on that. The other case I just want to show the court relates to the question of comparison. What are you comparing? What are you comparing? The question that was put to me a few moments ago, the question of the exercise of comparing what you've worked out as being a cumulative assessment, what are you comparing it with? And in particular, what are you comparing it with for climate change purposes? You have that in a case called Goza, Mr. Justice Holgate, tab 13. Within that, this was a challenge. You see this from page 391, paragraph 1. This was a challenge to the grant of planning permission for an airport runway extension. And we're concerned here with ground 3. Ground 3 you have starting on page 406. You see mention, although it's not in play again here. Page 409, paragraph 100. Again, Blewett is mentioned there. That's picked up in many, many places, but not in play in the present case. The issue here, though, is what one compares with. And at page 410, paragraph 107, and then picked up again later, Mr. Justice Holgate deals with the question of what you compare with in a climate change case. And the context, of course, is that climate change impacts are global. It's not like noise, which affects a local area, or dust, which affects a local area, or impacts on wildlife, which affects a local area and perhaps beyond. They are global, and that's recognised in this exercise. Paragraph 107, Chapter 13 of the environmental statement submitted by the applicant relied on this guidance, stated that the significance of emissions resulting from the proposal, that's an airport expansion and therefore aviation impacts, had been compared with UK carbon budgets of UK aviation emissions forecast and emissions from Eastleigh Borough Council, using also the experience of determining the significance of other projects. The authors stated, quotes, as climate change impacts are global in nature, it's not possible to link a specific proposed development with a specific environmental impact. As such, the sensitivity of receptors is not used to assess significance. Mr. Wolfe, rightly in my judgment, accepted that proposition. For the same reason, he made no complaints about the ultimate decision in this case not to compare GHG emissions of the project with any local measure based on Eastleigh. In other words, because the climate change impacts are global, you compare what you've calculated through your assessment and your cumulative assessment with the carbon budgets. That is how the system recognises the particular nature of climate change impacts. And that's picked up again by Mr. Justice Holgate, paragraph 123. Again, just to re-emphasise, no complaint is made about the way this element is done in the present cases. Para 123, there is simply no legal merit in the complaint that expressing project emissions as a percentage of national budgets or a target does not enable the decision maker to decide whether those emissions are compatible with achieving the benchmark or whether those emissions are affordable. And we take no point on that. We don't complain about the way in which things that were calculated were compared or not compared, being the problem, with national carbon budgets. There are not yet any local statutory carbon targets. Picking that then up with the way the judge summarised the position, and what I propose to do, if I may, is to show the court the way the judge summarised it and then show you some of the underlying documents, because the judge's summary is quite a helpful introduction into all of this. Moving, if I may, then to the judge's judgment, which is in the core bundle, page 79. Picking it up, if I may, within her judgment, at paragraph 20, first of all, she describes the situation of the three projects. As I'll show you in due course, the three related schemes are at paragraph 20, described, you'll see in the documents in due course, of part of the A47 improvement programme. The judge picks the crucial bits up, if I may, at paragraph 45 and following, page 96. Starting, if I may, towards the end of paragraph 45, about 6 lines before the end of the paragraph, last couple of words of the line. Whatever may have been the position earlier on in the proceedings, by the substantive hearing before me, there was no challenge by the Secretary of State / National Highways to the proposition that the three schemes are related projects and a cumulative impact was required. Well, there's no cross-appeal or challenge to the judge's characterisation of either of those things. Before the core dispute between the parties was on analysis the adequacy of the assessment of cumulative impacts. You then have a heading at the foot of the page, which is unhelpfully separated from its text, the assessment of carbon emissions in each of the road schemes. And that the judge summarised the position in half a dozen helpful paragraphs, which I'll just highlight to the court. Paragraph 47, the methodology was the same for all three schemes and may be summarised as follows. 48, the emissions from the construction of the schemes, so that's construction emissions. And in each case, you see here what's generated is a figure in mega or tera tons of carbon dioxide equivalent. Those figures we're not concerned directly here, or are not necessarily concerned directly here with the construction impacts. We go on to paragraph 49. The bulk of the carbon emissions from the scheme will be from traffic using the roads once they're operational, end-using traffic emissions. Just recall that those are as much part of the EIA regime as any other impacts. To assess these, traffic modelling was done, and that's then described. And then paragraph 50, the forecasts of future traffic took into account household employment growth as well as future developments in the area, which are more than likely or near certain. These included other major road schemes, including the Norwich West Link, which is a local authority but nonetheless substantial scheme, and of particular significance to the claim, the two other road schemes. So in the case of Scheme 1, the baseline included traffic growth from Scheme 2 and Scheme 3, and so on. And then 51, the carbon emissions were calculated over 3 key years, and that's then given. And then it says this, line 3, the baseline emissions or baseline estimates are referred to as the do minimum scenario and provided a baseline of anticipated traffic growth without the road scheme currently in place, which included the other two A47 schemes. And then 52, a do something figure of carbon emissions was then calculated. This comprised the carbon emissions from existing and future growth, including the other two A47 schemes, etc. So 2 figures are calculated, and I'll expand on this when I show you the documents. A DM, do minimum, and a DS, do something, both of which, in the case of each scheme, include the other schemes. So for the purpose of assessing each of the schemes, the decision maker here, and you'll see this in a moment, is being asked to assume that the other 2 schemes proceed. But that is done for all 3 schemes, even though they're all proceeding at the same time, and even though they all proceed as part of the same A47 improvements.
Going back to paragraph 45.
Paragraph, sorry, my lord.
45. What is the origin of the concept of related projects?
Well, it's a concept was a phrase that's used only within these documents. It's not a legal term of art.
Well, yes. So I mean, I appreciate that when one looks at this situation in the Norfolk area, and you see that these three projects are being advanced upon in knowledge of each other, and no doubt all part of an overall view of what is intended. But I mean, let's suppose that in Suffolk, 15 or 20 miles away, there's another bypass being contemplated, of which the minister is no doubt aware. I mean, would that be a related project?
Well,
or might it be a related project? Or?
It may or may not be, and the simple point here is that for the purposes of assessing these schemes, National Highways identified what it considered were the related elements, and they included the other A47 schemes and other things in the area. And the examining authorities proceeded on the same basis, and the Secretary of State proceeded on the same basis. And we don't complain about, this is not a case, and there are other cases in the bundle, we don't complain about their choice of schemes to go into that basket, that assessment, if you like. They made that evaluation. They decided what the related schemes were. It's not a term of art, as I've said. It's for the developer in the first instance and decision maker in the second to work out what goes in the cumulative assessment.
I understand the salami slicing point, which the judge had just made, which is that you can't get around things by simply cutting them up into small bits, so that you can't measure what's really going on. But you've explained that the concept of related projects is simply just firstly, matter of simple English as to what one might think was related, and that the Secretary of State, applying that, did think that these were related, but that there's no magic to the concept of the related project.
No. There's no magic to it. And we fully accept it's an evaluation to decide what the related, to use that word, but to put it into the statutory phraseology, the incumulation or cumulative, what goes into that is a matter for ultimately for the decision.
It might have been the case, for example, if there had been another couple of ring roads that were going on not far away, that there might have been some debate about whether they should have been considered related projects or not. But as it happens, that didn't happen.
No, that didn't happen. And as you'll see in due course, they chose the basket of things to go in there. We don't complain what goes in the basket. And importantly, for these purposes, it was then that set of related projects, to stick with that phraseology, which were regarded by the Secretary of State as being, as it were, appropriate, suitable, because that's what led the Secretary of State to say you've done a sufficient assessment. So we're not here concerned with what a lesser or a greater set of projects might have looked like. This is the set of projects that were in play here, selected by National Highways, assessed by examining authorities, assessed by Secretary of State, and the Secretary of State proceeded, as you'll see, in short order, on the basis that that was satisfactory because these were part of the picture. So we don't seek to disaggregate that. And there are cases in the bundle where people have brought a legal challenge to the decision as to what should be in scope of the cumulative assessment. For example, and there's two examples most obvious in the bundle. One is a waste incinerator which might have had a future extension for combined heat and power, and the question is, do you need to include what may or may not happen there? Another are fracking exploration sites which may or may not turn into production sites, and in each case the decision maker decided not to include what may or may not happen in the future, and the court said that was a lawful exercise of discretion. We're not concerned with one of those cases. We're concerned with a case where this is the set of related projects that were chosen. They were recognised to be related, and that was the basis on which everybody proceeded.
So your complaint is about what was done or not done with the schemes which were selected for the purposes of the comparison.
Exactly right.
So we're not in any kind of salami slicing.
We're not in any kind of salami slicing, no.
And we're not in any dispute, or in theory one can imagine the kind of case where there might be a dispute about which related schemes have been selected.
No, exactly right. Yeah, well, that's exactly right. So when we then get to paragraphs 51 and 52, what are produced, and this is the greenhouse gas emissions modelling resulting from all of that, are two figures in each case, or multiple figures, but fundamentally two figures, a dm and a ds, each of which includes all of the related schemes. That's the critical thing. And then 53, 54, so that's the description, if you like, that's the ES description. 53, 54 then explains what was done with that for the significance assessment. A comparison of the carbon emissions from the do minimum scenario without the proposed scheme and the do something scenario with the proposed scheme was then undertaken. And it says a comparison, it's a subtraction of two numbers, nothing more glorious than that.
Are these figures that appeared in the environmental statement?
They are, and I'm going to take the court to them in a moment. This produced a figure of the carbon emissions for the scheme only, i.e. an assessment of the carbon emissions associated with the project, which was then compared against the three carbon budgets. So DM and DS both included the related schemes, and to use the language that you'll see in due course, took account of the related schemes. But because what was done, DS minus DM, as it were, the related schemes were in both parts of that calculation. So whilst one took account of the schemes, you added them in and then took them away again. So what you're left with, the DS minus DM figure, is only the figure for the scheme. And it's then that DS minus change in carbon emissions resulting from the road scheme in question was then estimated as a percentage of the UK carbon budgets. Now, we don't complain about that as being an assessment of the impact of the scheme on its own and its significance of the impact of the scheme on its own, but what it isn't is an impact of the significance of the cumulative impacts.
Just pause. Thank you.
What is not done, and this is the fatal step, is to compare that cumulative assessment with the national carbon budgets and then to factor that into the question of whether development consent should be granted. And there's no argument against us to say that if that latter exercise had been done, the result would inevitably have been the same. This is not a case where it's said that the evaluation wouldn't have made a difference. Just to then do what my Lord was contemplating a moment ago and show you those figures, if I may, in the environmental statements. You have these in supplementary bundle. Tabs 1, 2 and 3 deal with the three schemes. I'll just show you the environmental statements in sequence. I will, if I may, show you each of them because they're all slightly different, although they follow the same.
What are we going to gain from going to the original documents?
I
mean, we're here concerned with the point of principle. I mean, I appreciate it's useful if we can understand.
Well, I mean,
to some degree. I mean, would you like to take this with quite a light touch, illustratively rather than exhaustively?
I'm happy to do that, my lord. I'll look at an ES and then an examining authority.
I mean, it might be helpful, for example, if you want to look at one of them in some little detail, by all means. But
let me look at scheme 2,
right,
which is tab 2. So you have. Having said that, I do need to show you something from scheme 1. But anyway, because you don't have a complete set of all the documents, no matter. Tab 2 is the Tuddenham. So this is scheme 2, claim 2. You have an extract here from the environmental statement, and as you see from page 86, you have chapter 14, climate. And within that, diving in with my lord's words in mind, picking it up at page 100 in your bundle, heading above, well, by paragraph 14.7, section 14.7 is baseline conditions, and then heading above 14.7.2, existing scheme emissions. The baseline against which the proposed scheme has been compared with is the do minimum scenario, the future baseline without the proposed scheme in place. And then it explains what that says. Now, it's not immediately clear from these documents, and later documents make this clear, what goes into that. But what becomes clear as you look at the examining authority and then the Secretary of State's decision is that everybody proceeds on the understanding that the DM includes the greenhouse gas impacts of all of those what we called related schemes. There's a bit of an explanation, but it doesn't entirely shed light on that point at 14.7.3. But what matters is that DM includes all the related schemes, but not the particular scheme in question. So here we are, DM2 includes DM1, includes the scheme 1 and scheme 3, but not scheme 2, so if that's immediately obvious. Then 14.8, this is page 103, potential impacts, heading is effects on climate. That is divided then above 14.8.2, the heading is construction, and then above 14.8.4 the heading is operation, and at 14.8.5 for end user traffic emissions, a comparison of the do minimum without the proposed scheme and do something with the proposed scheme has been undertaken based on the proposed scheme year, etc. So that's what you've seen from the judge. And then summary at the top of page 104, 14.8.7, the net change in emissions has been calculated by comparing the baseline, DM, the DS. And we then have some tables, the first of which I think is less critical. Now let me just show it to you anyway, 14.9. What that has done, if you look at, divides it into construction and operation, as you'd expect. And it gives us accumulated over the carbon budgets, and that's legally problematic, but let's not worry about that for the moment. It gives us construction figure, and it gives us an operation figure, but the second column is the net, the DS minus the DM. So we don't get much from this table because there's a better table in a moment, but what we do get in this table, in the three right-hand columns, are the three carbon budget figures. So that's where you see in the ES, this ES, the three carbon budget figures. And we can track those back to as Justice Holgate if we need to. And then at 14.8.8, the increase in carbon emissions resulting from the proposed scheme represents up to approximately 0.04% of the UK's 4th, 5th and 6th carbon budgets over their respective periods. So that's the comparison figure that's then taken forward. That's the contextualisation.
Where were you just reading from?
14.8.8. That's the GOSA figure, if you like, albeit that it's combined for the three carbon budget periods. Let's not worry about that latter bit for the moment. But that, just to be clear, is the only figure, that's the only point where something is compared with the carbon budgets to give a sense of scale, if I can put it that way. But what's compared is DS minus DM. That table, or at least the raw figures in that table, come from 14.10, table 14.10, which is over the page on 106. And this is broken down a little bit more. So here, what we see in the columns, 4th, 5th and 6th carbon budget. So we are concerned, or the Secretary of State ought to be concerned, about the impact of this project in each of those periods, and it has a different impact in each of those periods because its construction impacts are in the beginning of that period, and then its operational impacts change over time. What's then calculated, as you've seen, is a baseline figure. So you've got the figures 2848 and going across there. A baseline, the DM figure in each case for each of those carbon budget periods. Then the DS figure, this is rows 2 and 3, comes in two parts. Construction, which only occurs in the first period because that's when the construction impacts are, and then operation, which occurs across all three budgets. So you have the DS total line, which is the fourth line of the fourth row of the table. In the 4th carbon budget period, that's construction and operation DS. In the 5th, it's operation only, and in the 6th, it's operation only. So we have a DS figure for each of the periods. We have a DM figure for each of the periods. So we know what the impacts of the related schemes and this scheme are from DS, and we know what the impacts of the related scheme without this scheme are from the DM, as assessed by National Highways. Dr. Boswell does not, for these purposes, dispute these figures. What is then calculated is the DS minus DM figure. That's the last line of the table, numerically taking, as it were, the two figures from the column, from the rows above. And it's those figures, the 111626, the 4695, and the 41774, which have been compared, a bit of a gymnastics here, with the three carbon budget figures that we got in table 14.9 to get you the 0.004.
Thank you.
So the only exercise of comparison is by reference to the DS minus DM figure, and that's the tricky bit. So that's this scheme. In relation to the examining authority reports, again, I won't show them to you all because they follow broadly a similar pattern. Just picking up the same examining authority report.
So what are we going to now?
Examining authorities report. So this is in the supplementary bundle, same tab 2 for the same scheme.
Yes.
So the extract of the report starts at page 118. And within that, you have page 129, section 2.4, relevant planning history. And this describes, as it were, the wider context, the history of the proposed development set out in chapter 3 of the ES, feasibility study for the A47 corridor to identify issues on the SRN, that strategic road network. Then 2.4.4, in December 2014, the Department of Transport published its road investment strategy. The RAS includes a package of 6 schemes to be developed and constructed during RAS period 1 and RAS period 2 to improve journeys on the A47 between Peterborough and Great Yarmouth. These schemes have been branded as the A47 Improvement Programme. That's where I got that phraseology from. So whatever else is in the related schemes basket, and we know that these schemes are, these 3 schemes are part of the A47 improvement process. They are not unconnected schemes. It's been said, well, what about a scheme in Oxfordshire? That's not part of the A47 improvement programme. And the important point, to go back to the dialogue we had earlier, is that it's these schemes have been chosen by National Highways and the Secretary of State to be part of the related schemes for this development, each of these developments.
I mean, surely there's an element of randomness about that, notwithstanding. I mean, the A47 goes from Leicester to Great Yarmouth. I mean, the fact that it happens to be a very long road crossing half the country doesn't mean that places at one end or the other of it are necessarily related to each other simply because it happens to be the same bit of tarmac.
No, absolutely, no, but that's not any part of this case, doesn't need to be any part of this case. I only show you this to explain why it made sense for them to include the 3 schemes together in related schemes. They were all part of the improvement programme. There might have been a separate and different argument had that not been done, but that's not any part of this case. And as you'll see in a few minutes, the Secretary of State's acceptance of all of this is premised on the inclusion of these schemes in the calculation.
We're seeing from the title of this part of the documentation, which is the examiner's report, that excluding appendices, it's about a 300-page document. Just to give us a sense of the scale, you took us to the environmental statement at part 14, for the relevant part. What is the scale of an environmental statement?
They can be very substantial in terms of numbers of pages. Is that the kind of
yes
because they will include assessments of all sorts of impacts. In these particular cases, there were particular concerns about bats.
Yes, I'm presuming that they're thousands of pages long.
They certainly can be. Yes.
For something as big as this.
Absolutely, absolutely, and with documents behind them. So behind those figures in the ES, what the public didn't see and doesn't get is the workings out that generated those figures. The public gets those figures, so that's why Dr. Boswell has worked from those figures. He hasn't gone away and done his own calculations. He's said these are the figures you give us. What's done with them?
Right.
But my lord, just contextualise that. It's not been said, for example, as I indicated before, that the climate impacts, whatever they were, are such that they can be ignored in the process in the context of all the other things. But my lord is right. An ES for schemes like this will be potentially thousands of pages.
Thank you.
That proposition at 2.4.4 is picked up to some extent on the facing page, other strategic projects and proposals, and the heading under that, there's two headings under that, other A47 schemes and the Norwich Western Link Road. So those are other major road schemes, 3 being brought forward by National Highways, 1 being brought forward by the local authority, all taken to be part of the related projects for the the DM and DS calculations. Within this document, you then have a chapter starting climate change, page 134 of your bundle. And within that, page 139, there's a heading planning issues. The heading above paragraph 5736. And above 5737, you see a heading XA questions. And at 538, the examining authority in their report to the minister says this: following a number of comments from interested parties, members of the public essentially, and the discussions at various hearings, I sought a response from the applicant in relation to the following. Please can the applicant provide, or to the extent that any of the below has already been provided to the examination, identify its assessment of the cumulative effects of greenhouse gas emissions from the scheme with other existing or approved projects on a local, regional, national level, or on a consistent geographical scale, for example, an assessment of cumulative impacts of the road investment strategy, RAS2 at a national level. So that's asking a question. Please tell us what or please point to the cumulative environmental assessment you have done. By reference to 2 different things. One is geography scale, one to some extent is what the target is. You then see page 141 and following under the heading IP responses. Within that, at 5744 on page 142, throughout the examination, a number of submissions were received from Dr. Boswell. In terms of the issues which the comprehensive and detailed submissions raised, some are included in the above list. However, I've summarised others below. And the first one is the point with which we're concerned here. The assessment of carbon emissions in the ES is inherently soulless, and no cumulative assessment has been made of carbon emissions with other A47 schemes. Now, what he means by that, and you'll see this unpacked in a moment, is you've used the DS minus DM figure to compare with the carbon budgets. So what you're comparing under the label of cumulative assessment is actually scheme only. Heading further down the page, the applicant's position. Within that section, page 143, this is introduced at 5752. The applicant confirmed their assessment of greenhouse gases had assessed the construction and operational effects. And then at 5753, we get phraseology which we'll see echoed again in other places. The traffic modelling was undertaken in accordance with TAG published by the Department for Transport. The traffic model for the proposed use of the proposed development was developed in line with DFT requirements, and in the view of the applicant was inherently cumulative. This was because traffic models used to support the assessment of the proposed development contain data about the following. And then there's 3 bullets: proposed development and adjoining SRN and local road network, other proposed developments proposed by NH in the near vicinity of the proposed development, etc. So what they are saying, and this is echoed in other places, slightly different phraseology in each place, is our assessment is inherently cumulative, important words, because the assessment contains data about. Now, we don't dispute, just to look at the literal black letter meaning of those words, that the assessments contain data about, and I've shown you how that works. DM and DS both contain data about other schemes that they have chosen to include within that calculation. If you like, that can be called inherently cumulative because there's data in the calculation. Does that make it, however, a calculation of the cumulative impact of the scheme? No. And inherently cumulative is not some proxy legal test, and yet it appears to have gained that status in this process. Containing within the calculation data about other schemes that you have chosen to include does not make the result necessarily a cumulative assessment. And the court can now see, and I've shown you how the numbers work, how that works. The other schemes are in DM, they're in DS, you take DM from DS, and you get the net figure. So in one sense, that is the provenance of the problem, which then propagates through the process. That is then further illuminated at 5755. In essence, as both with and without scheme scenarios already include all likely developments and traffic growth factors, the applicants consider that the assessment is therefore inherently cumulative. So same language again.
I'm so sorry, which paragraph is that?
5755.
575, thank you.
You then see over the page at 145.
You probably should read 5756.
I must read 5756. With regards to national carbon budgets, the applicants submitted that these were also cumulative, as they represented the sum of carbon emissions from a range of sectors between now and the end of the sixth carbon budget. The applicant considered that the Climate Change Act 2019, that must be the amended version, does not impose a legal duty to set carbon budgets at a smaller scale, i.e. regional or local.
Right, so that's what they mean by cumulative. What do you mean by cumulative?
In this context, a cumulative assessment would be a comparison between the scheme impacts in cumulation with the other schemes, whatever they may be, against the national carbon budgets. And if I just play the documents through in a bit, you'll see how the Secretary of State...
We ought to be able to do this without reference to any particular documents. Would you mind just restating what you describe as a lawfully performed cumulative assessment?
It would be the total GHG for the scheme. I'm going to try and use the legal framework for in cumulation with the other existing or approved projects. That's the language of the regulations.
I'm finding it a little difficult at the moment to understand what the difference between that is and what actually happened.
Well, what actually happened is that what was compared, the figure that was, so I need to finish the idea if you like, is that figure then needs to, whatever it may be, and we're not here arguing about the calculation itself, needs to be the one that's compared with carbon budgets. So it's the scheme in cumulation with the other projects compared against carbon budgets. And what you have here is the scheme in cumulation with carbon budgets, take away the accumulation bit, the DS minus DM. The problem...
But you do it 3 times.
I'm sorry?
But you do it 3 times.
Well, no, you don't do it 3 times. You don't do it 3 times. That's the problem here. DS is scheme plus others. DM is others. DS minus DM is only scheme. And what's compared is DS minus DM. I'm not sure what my Lord has in mind as the 3rd time.
Well, once for each of the 3 schemes.
Once for each of the schemes.
Yes.
But you, I'm sorry, I've misunderstood.
Yes, because I know I've discouraged you from taking us to all the 3 schemes, but it's been useful to look at least one of them to see how it's framed. But, I mean, the difference is between getting 3 numbers, putting them together, and thinking, is this, quote, affordable in carbon terms? Or getting 3 numbers, not putting them together, and looking at each of them and thinking, as to each of them, is this affordable? In knowledge of the other 2.
Well, it's the in knowledge of the other 2 that's the
Well, it is in knowledge of the other 2, because we've achieved the fact that we've got to the contained data about, that there's no complaint that, as there very often is in this sort of situation, that somebody's completely left out of account important materials that would bear on the judgment. Whereas here, we're approaching it on the happy basis that, for purposes of our argument, everything that was there should have been there. Simply a question of how you organise it.
My Lord, yes. If apologies if I misunderstood the way my Lord's explaining it. The difficulty is that each of the DM figures proceeds on the basis that the other schemes go ahead. So there's no point at which you stand back and say, should these, to understand another way of putting it, would be to say, should these 3 schemes go ahead? I've got the impact of A, B and C. Let me look at those 3 individual impacts and say, should the scheme go ahead? So all three schemes go ahead. That exercise is not done. What's done is for each individual scheme is to do a calculation which includes but then takes away again the other schemes, and therefore in effect assumes the other schemes are given. That's the difficulty. Each scheme here, the decision...
It assumes they go ahead.
It assumes they go ahead, yes.
But I could understand your complaint if it was an assumption that they didn't go ahead, because that would seem to make the carbon hurdle easier to cross. But if the assumption is going to be that they do go ahead, that would seem to be something that you could be expected to favour.
Well, we don't complain. We don't complain about looking at the DM figure, if you like. The difficulty is that when you make each of these schemes go ahead, in related schemes as they are, that the evaluation is not does this. And the whole point of a cumulative calculation, the whole point of the exercise, is recognising that projects are going ahead together and saying. Should each of these projects not be considered in isolation, but should it proceed on its own? And the danger that's illustrated by what's going on here is, in effect, each scheme says, well, the others are taken as given. I'm going to proceed with this scheme. I'm going to decide where to proceed with this scheme anyway. And that's problematic. That's problematic, given that these are, as we've seen, related schemes which are all going forward at the same time. Therein lies the vice. Otherwise, what's the point of the DS minus DM exercise?
Thank you.
So the only point at which we get, the only comparison we have is not, to use the language of Dr. Boswell, and it's picked up in the EXA report, the only comparison is effectively a solus exercise. It's the exercise of saying this scheme on its own, the impacts of this scheme on its own compared to the carbon budgets. There's not a comparison. There's not a comparison between this scheme and the other schemes against carbon budgets at any point. At any point. Yeah. And it's not an answer. Just if I may be misunderstanding my Lord's proposition. It's not an answer to say this other figure is floating about, because that other figure is never compared to carbon budgets. I may have interrupted you.
Not at all. I'm just really perhaps thinking aloud. Is another way of putting your complaint to say that because each scheme yields ultimately what Mr. Boswell calls a solus figure, and the Secretary of State in each case took the view that that figure viewed in isolation was not significant, it was beneath any threshold of significance. Mm-hmm. That doesn't necessarily answer the question whether if you add them, take them cumulatively, mm-hmm. as you say you should, that the product could be a difference which is significant and therefore needs to be assessed as such.
Indeed, and just to go back to my Lord's point, which I may have misunderstood, apologies if I misunderstood it, in each case, the figures, one needs to separate out for this purpose, the calculation of a number and what is then done with the number, and both parts are important. And so floating around in the ES are various numbers. In each case, there is a DM figure that is this scheme, is assuming all the other schemes go ahead. That's a calculation. That figure is never compared to the carbon budgets figure. There's also a figure floating around, which is the DS figure, which is those schemes plus this schemes. That figure is floating around. Subject to something I'll say in a moment. That figure is not compared to carbon budgets. So we have a description of the impacts of the other schemes, to go back to the language of the ES. We don't have, for Regulation 21 purposes, the assessment of the significance of this scheme in cumulation with them. So you can run this round in different ways, but what always matters is both what we call enumeration, but it can be a description, because in some cases it won't be a number, but let's call it enumeration, and the contextualization of that.
I understand.
That's the fundamental flaw. So just to pick that up further in this examining authority's report, over the page at 145, you have a heading which is isolated from its text, Table 2, and then on 146, you have a faithful copying of the table that the court's already seen from the environmental statement. So the EXA understands that. Then the EXA's conclusions on page 149, and these are conclusions which the Secretary of State specifically adopts in the decision letter. I agree with Dr. Boswell and others that the emissions from the proposed development should not be viewed in isolation. the applicant did not provide a separate assessment of a cumulative impact of proposed development with the other high-waste developments, either locally or nationally. And that's entirely right. What they provided was various figures, but the only assessment, in the sense it's being used there, that's provided is scheme only, solus, if you like. However, they considered that the government's carbon budgets are themselves cumulative. Furthermore, they identified that the traffic model used to assess the proposed development is also inherently cumulative for a number of reasons. And then it's explained, but the court's now got the basic proposition. So, inherently cumulative for the underlying numbers means those other things have been taken into account but then abstracted, removed. So yes, they are part of the numeric journey, but arithmetically, for the DS minus DM reasons, they are not in the end part of what is actually assessed. And the examining authority is entirely right to say did not provide a separate assessment of cumulative impacts. That's entirely right. And the explanation is twofold. One, carbon budgets are cumulative. Two, the traffic model is inherently cumulative. Let's just take those in sequence. Carbon budgets are cumulative. Yes, carbon budgets are the assessment of what it is the Secretary of State as an overarching legal obligation has got to do his or her best to make sure we reach by certain periods of time. In that sense, they are the accumulation of everything we all do. But they're not in any sense, they're the target, they're the aspiration, they're the benchmark, if you like. They're not in any sense an accumulation of this project with any related projects. And then second limb, the traffic model is inherently cumulative for a number of reasons. Somewhere along the calculation, we've included the other schemes in the process. What then happens, I'm just sticking with scheme 2 for a moment, the schemes came, the decisions were made, the examining authorities were made in fairly quick succession. By the time we get to scheme 2, Dr. Boswell had just commenced his judicial review on scheme 1. He commences his JR on scheme 1 on the 1st of August of 2022. That is relevant because what we then see is ministerial submissions, which I'm just going to show you very, very briefly, which are at page 157 and following. So, this is, as it were, not an afterthought, I don't mean afterthought in a rude sense. This is picking up the fact that Dr. Boswell has brought proceedings on JR1. That feeds into JR2. What you see, this is at page 160. Paragraph 12. Officials approach, this is on 161. Officials note the applicant's arguments that the traffic model that was developed in line with the department's requirements and used to assess the proposed development is inherently cumulative, as it includes data about the proposed development, etc. So, includes data about. So, slightly different formulation. We've had takes into account. We've now got includes data about. But it's data which comes into the calculation and then goes out of the calculation. What then follows from this, and you just see this on page 163, my Lord asked what we say needs to happen, and to some extent that's picked up, and I only say to some extent, it's picked up in schemes 2 and 3 in this way. So the paragraph on page 163, which starts with the number 1, the indented paragraph, the Minister is being asked to approve as an additional paragraph to go into an existing draft decision letter. So it's this. The Secretary of State notes that interested parties like Dr. Boswell have argued that a cumulative assessment requires one to consider the combined emissions from the proposed development alongside other developments that are included within the do minimum scenario as against carbon budgets. Whilst the Secretary of State does not agree it's necessary to do this in addition to what's been done by the applicant, and that's the legal question, for the reasons already stated, the Secretary of State notes that the combined emissions are reported within Table 14.9 of the revised ES. This identifies the total emissions in the do something scenario would be, gives the figure, over the 4th, 5th and 6th carbon budget periods. These combined emissions equate to 0.263% of those combined budgets, and the Secretary of State then deals with that. That's the fallback position. The Secretary of State says, I don't need to do this, but if I do what you're saying, I would compare DS with carbon budgets, and that is indeed what, as it happens, Dr. Boswell said is missing given these numbers. And that's the calculation that would involve comparing something that included the schemes in the final number with carbon budgets, as opposed to something which didn't include the carbon schemes, although it was based on a number which had at various points had the other schemes come in and out of the calculation. And that's the fundamental stepping point. The legality of the approach to that 0.263 figure, I mean, my lords may have seen that there was a second ground of challenge in JR2 and JR3, which the judge didn't go on to deal with because she found against the claimant, the appellant, on ground 1. So the legality of the way the Secretary of State gets to the 0.263 figure is not directly before this court. I mean, just so that the court understands it, that the fundamental complaint is that what's been done there is to aggregate the 3 carbon budget figures and to put together the figure generated for CB 4, 5 and 6 and put together the carbon budgets for C4, 5 and 6, which Dr. Boswell says is unlawful because you can't aggregate carbon budgets in that way. And just for the court's note, he's done, you may have seen the figure in the judgment, he's done that exercise. This is page 280 in the same bundle. He says you can't, as a matter of law, combine the figure from the 3 carbon budgets. You have to do it carbon budget by carbon budget. And he's used for this purpose the figures that come from the environmental statement. And this is on page 280. And it's the table on 280. And it's the entry, the line B, the row B, I'm sorry. A as a percentage of UK carbon budget. And he's disaggregated it for the 3 carbon budgets, 0.15%, 0.27%, 0.47%. So his legal complaint on the fallback, which isn't directly before the court, is that the Secretary of State's 0.263 figure unlawfully aggregates carbon budgets. And actually, if you look at it in the context of CB6, which is the hard to achieve one, see Mr. Justice Holgate, you get a figure of 0.47. So that issue is not directly before the court because the judge didn't deal with it. But just as a partial answer to my lord's earlier question, that is the kind of exercise that Dr. Boswell says should have been done, entirely using their figures. He's not quibbling with their figures. He's not quibbling with their choice of which schemes go into the calculation. He's saying, on the only figures you've given us for scheme plus related schemes, this is the numeric and therefore legal consequence of all of that. So I hope and then that paragraph feeds in to the Secretary of State's decision letter. In terms of the decision letter on that scheme, you have this in the other bundle, in the core bundle. You have all the 3 decision letters in tab 10. This decision letter starts at page 417. And within that, at 424, there's a section headed Climate Change, just to contextualise the paragraphs we're looking at. Within that, at paragraph 84, you see, just to dive into the middle of it, you've now seen, the court's now seen the provenance of this valuation. 6 lines down towards the end of the line would represent 0.004% of the 4th budget, 4th, 5th and 6th budgets. But that is the only point at which the Secretary of State does the Regulation 21 exercise of taking the description and evaluating its significance, because that's the only point at which there's a comparison between an enumerated climate change impact and the carbon budget threshold. And that propagates across all 3 decision letters. But that, without repeating myself boringly, is only, because of the way the calculation's been done, the scheme on its own. Within the decision letter, the Secretary of State then at page 428 picks up as a heading cumulative effect. Paragraph 90, the Secretary of State agrees with the examining authority that emissions from the proposed development should not be viewed in isolation. and notes that the applicant did not provide a separate assessment of cumulative impacts of the proposed development with other local or highways projects. That's the point I showed you before. Picks up Dr. Boswell's complaints you see in the following part of paragraph 90. And then in 91, picks up the applicant's arguments. The applicant, however, argues that national carbon budgets are themselves cumulative. Well, we agree with that as far as it goes. Not an answer to the issue here, though. And the traffic model used to assess the proposed development is also inherently cumulative, as it includes data about the following. And that list includes, amongst other things, the two other schemes. You see, each decision letter explains it slightly differently, but that's the gist of it. For better or for worse, everybody, if you like, in this litigation is working with that calculation of what the related schemes were. And the important point is, the Secretary of State approves these DCOs on the basis that the developer has included data about those schemes. So we are not concerned with a hypothetical of what other schemes might have been included or what lesser bundle of schemes might have been lawful. That's a different case and a different day. This is the bundle of schemes that was put forward and formed the basis of the Secretary of State's decision. So the point my Lord put to me earlier on, what about a scheme in Suffolk? What about a scheme on the A47 near Leicester? That's not any part of this case, one way or the other. Or equally, it's not any part of this case to say, well, you could have left this one out or included that one. This is the bundle of schemes that was put forward for this calculation, which the Secretary of State then says, on the basis of this, I'm satisfied that you've done the job. And that's where we get the legal error.
Can I just ask a question on my understanding? So your real complaint is that the do something figure takes away then the do minimum figure, but the do minimum figure is artificially inflated by assuming success on schemes 1 and 3 for scheme 2.
That's another way of putting it, my Lord, exactly right.
Okay,
My Lord exactly has the mechanics.
Sorry to interrupt.
This is then slightly illuminated. I'll just show you, this is the decision letter, so I do need to show you this in a little bit more detail. The applicant stated in its response to the Secretary of State's third request for comments, the approach to climate assessment within the methodology, so this is para 92 if I didn't say that, is inherently cumulative through the inclusion of the proposed development and other local development within the traffic model. And then 93, about this paragraph deals with both operation, different aspects of various things, but the last 4 lines, the applicant therefore considered that the assessment takes account of the proposed development and other developments likely to have an influence. Again, it's that language of takes account of. Well, the calculation has taken account of them, but exactly in the way my Lord has just helpfully explained back to me, and you clearly have the point. So the language of takes account of or includes needs unpacking in this context, is the way that we would put it. Anyway, on that basis, the Secretary of State concludes, paragraph 95 towards the end of the paragraph. He sets out, he explains, and there's no dispute about this, there's no one way of doing these kind of calculations. That's absolutely right. That leaves the Secretary of State at the end of 95 to say, the Secretary of State agrees with the examining authority that the applicant's approach to assessing the impact of the proposed development on carbon emissions and its cumulative impact is acceptable. And it's the last bit that's problematic, because what the applicant hasn't done is to assess the cumulative impact of the development in the sense of both enumerating it and assessing its significance.
Another concept is introduced in that paragraph of absolute emissions. See in the 5th line, 6th line.
Yes, I'm not sure quite where that word comes from. It may be to contradistinct the difference between the DM and the DS figures. It may be that we can track that down. But that's the fundamental vice is that you don't include, or you don't include the other schemes in the DM and the DS calculation if it's the difference that you're going to carry forward. To take my Lord's question again. Just to see the flow of the Secretary of State's decision letter, so that the Secretary of State approves this on that basis, it's inherently cumulative because it includes the other schemes. then says this at 96, he's also noted the applicant considered that national carbon budgets are inherently cumulative as they include the total carbon emissions from a wide range of sectors. So that's not part of the core reasoning, what the Secretary of State signed off. It's mentioned nonetheless, and it's mentioned importantly. As I think I've indicated, we accept, of course, that the carbon budgets are cumulative. Indeed, that's in their very nature. They are the accumulation of what has to be achieved. Therefore, they are an appropriate benchmark against which, indeed, they're a necessary benchmark against which to assess whether or not each of these schemes or all of these schemes should go ahead. That doesn't take the thinking any further forward. It doesn't make the developers' proposals here or the Secretary of State's approaches to it a cumulative assessment of this scheme along with those other schemes. And of course, that broad approach, each of the other decision letters, each of the other ESs is slightly different, each of the other examining authority reports is slightly different, each of the other decision letters is slightly different. The only structural difference is that Scheme 2 and Scheme 3, you have this fallback calculation done. Doesn't appear in Scheme 1 because of the chronology. But that fallback calculation, whilst it's not live before the court, at least illustrates a partial answer, at least, to what my Lord asked me, I think, earlier in the morning.
What would you say to the possible rejection that your approach is ultimately a rather formalistic one, in the sense that we're dealing on any view here with three relatively small-scale road improvement schemes, each of which, viewed in isolation, has an effect on greenhouse gases, which, on any reasonable assessment, is insignificant. And although it may be said the global comparison, which you say should be carried out, was omitted, but subject to the fallback consideration given in the second and third schemes, was it not open to the Secretary of State to stand back from it all and say, really, these are, in the global scheme, very trivial amounts, and you know, if schemes of this kind are not going to get through the net, well, really nothing is going to get through the net, and the purpose of these elaborate systems is not to prevent development, but just to ensure that we remain on target to meet our ultimate climate change objectives at the end of the
Well, the Secretary of State could have approached it in other different ways. This is the way in which he approached it.
Yeah.
So there was no dispute here, and you've seen the judge's characterisation of this, that there needed to be the cumulative assessment. That there's no complaint about what was fed into that calculation. You've seen that.
Yes.
The Secretary of State doesn't, at the end of the day, say, as my Lord's perhaps contemplating, these are tiny numbers. I mean, I'm just putting words into his mouth, and that's the important
putting
thing.
it in very layman's terms.
Well, yes, but two things. First of all, when I introduced the Climate Change Act, I made the point that everything, the climate change numbers, the global, are big numbers, but they are targets which have to be met by a large number of decisions on what are all small things. There is no possible development in the UK that would have a large number impact on the climate change budgets. One can't envisage something that would have something more than these relatively small numbers. That's important context. And yet, not formalistically at all, the Climate Change Act feeds into the Planning Act and feeds directly into the EIA regime. Completely mindful. The Climate Change Act was passed shortly before the Planning Act. The Planning Act could have said, and the EIA regulations which deal with NSIPs could have said, don't take account of climate. They didn't. They absolutely specifically said, take account of climate and cumulative impacts. That's how they're framed. That feeds into the weather question, the WH weather question. It also no doubt feeds into the weather WE question, but we're concerned with the first of those. And importantly, this whole calculation was gone through, leading to various figures, none of which was said to be so small as to not make any potential difference. And there is no argument against the appellant to say, for example, the 0.47 figure, which he calculates, or even the 0.26 figure, is such that it would have made no difference to calculation. That's the important thing. And just to bear that in mind, when one gets to even the 0.26, but certainly the 0.47 figure, what is being said is that, in some sense, to put the scale point the other way round, a relatively small bit of the UK's carbon highways network around Norwich will, by Carbon Budget 6, if these schemes are approved and built, contribute nearly 0.5% of the UK's entire budget. Now, given all the other things that have got to happen in that period to get down to those the percentage reduction, that starts to become significant and important. And go back to what I said at the beginning, these are not things that can be turned on and off. There are other aspects of our public life where the government can say, right, you can, let's say, burn coal, now stop burning coal, burn oil, now stop burning oil. These are one-off decisions about road schemes, and that's why this matters. If one could simply say everything we do is a very small number in climate change impacts, then we wouldn't have the panoply of a net zero strategy, which has been heavily litigated. We wouldn't have this kind of decision-making framework. The important thing about climate change is that every bit matters, including things that, coming to it cold, you might think were fairly small numbers. Had the Secretary of State said, there doesn't need to be a cumulative impact assessment here, because these are small numbers, we'd have a different case. That's not what he said. That's why I showed you this decision. Everybody recognised you needed to do a cumulative impact assessment of carbon, climate change impacts, including of the road schemes. That's the starting point for all of this.
Yeah.
Secretary of State doesn't go down the road that my Lord's question, I think, possibly contemplates.
Right. How are we getting on?
Very well indeed, my Lord. Can I then look at it just by reference to what the judge said? The judge helpfully summarises her reasoning at paragraph 6.
Reference again, please.
It's page 81, I'm sorry, of the bundle, that's the question. Paragraph 6 is a summary, and I'll just pick it up in the summary if I may. For the reasons that follow, I've reached the view that whilst in parts unhelpfully expressed, the approach taken to the assessment of cumulative impacts does not breach the regulations. My conclusion is based on the following. And then over the page, sub 1, the question of what impacts should be addressed cumulatively, how those impacts might occur, whether they're likely to be significant, and if so, how they should be assessed, are all matters of evaluative judgment for the Secretary of State. Pausing for a second there. Her references, paragraph 43 and 77, and those paragraphs are referring effectively to Blewett and the case law around environmental statements. So the question, so if what's being said is the adequacy of the raw environmental statement, the Blewett point, is a matter of evaluative judgment for the decision maker, so far so good. But that's not our case. Our case is not a complaint about the raw ES, it's a complaint about the way what's used in the ES is dealt with, and so it's not a Blewett complaint. So paragraph 1 is not addressing the issue in this case. Then it's number 2, little Roman 2, the carbon emissions from each road scheme were calculated and compared against the UK's national carbon budget. That's correct. 3, consideration was given to the cumulative impact of carbon emissions from the 3 road schemes. Yes, consideration was given, but this court now understands what that means. A figure was produced for the combined emissions from the 3 schemes and other local schemes, therefore satisfying the requirements of Schedule 4, paragraph 5 for a description of the likely significant impacts of development, etc. The figure produced was not, however, assessed for significance against the UK's national carbon budgets. That's entirely the essence of the point. So that figure was produced, the court's seen it, it's the DS figure in each case, but that figure was not assessed for significance against the UK's national carbon budgets. This was a matter of evaluative judgment for the Secretary of State. That's the crunch, because that's to miss out the critical steps within Regulation 21, Regulation 5 and into 21. So the figure was produced and the judge rightly recognises that, and that description is there in the ES. That's why, if you like, we don't complain about the ES as a freestanding entity, because that figure, the cumulative figure, is in the ES. But what carries forward into the Regulation 21 evaluation is not DS, compared to carbon budgets, it's DS minus DM. The Secretary of State's reasons for not comparing the combined emissions against the national target were, broadly speaking, threefold. There is no single prescribed approach to assessing cumulative impacts of carbon emissions. Obviously, absolutely right. Dr. Boswell is not suggesting a different approach to assessing it. Dr. Boswell is precisely adopting the approach which is advocated by the developer and by the Secretary of State. He's used at every stage their figures, if you like. The approach to assessing the cumulative impacts of carbon emissions differs from that of other environmental impacts because carbon emissions are not geographically limited to a local area. Absolutely correct. That's why, go back to Goza, you don't compare against some, let's say, Norfolk or East Anglia figure. You compare against carbon budgets. That's the aggregation effect. The appropriate basis for assessing the significant effect of emissions was to compare them against the UK's national carbon budgets. Again, entirely correct. We agree with that. But even if this were a discretionary exercise, even if it were a discretion as to whether or not to do this calculation, which we say isn't, because that's not what Regulation 21 means, those are not lawful, they're not logically coherent reasons for not doing that exercise. They don't actually answer the problem. Then we go to paragraph 5. Recent case law confirms that on the basis of current policy and law, it's permissible for a decision maker to look at the scale of carbon emissions relative to a national target. Agree, that's what we say should have happened. And then paragraph 6, accordingly, there is a logical coherence to the Secretary of State's decision not to compare the combined emissions from local road schemes against the UK's national carbon targets, etc. That's not the issue, or is the issue, is not the issue. And logical coherence has to read the previous paragraphs above, and there is no logical coherence, we say, because the reasons given, that's Roman 3, don't amount to a reason not to do the comparison, which we say Regulation 21 requires. The simple point is there has not been an assessment of the significance of this scheme with related schemes. What there's been is an assessment of the significance of this scheme on its own, which in the numbers on the way has taken into account, but then taken back out of account the other schemes. And that's the critical gap. And that's not answered by my lords, these are small numbers point, in the context of this legal regime. These are mandatory legal requirements. And they weren't bypassed. It would have been a different case had they been bypassed by the Secretary of State simply saying, I don't need to do this exercise. It was agreed, and that was why I showed you that passage in the report and the decision letter, that they needed to be the cumulative assessment, and that's simply not what's happened. Well, if I can just take a moment. Yes, I'm suggesting I make the point in relation to the questions that were asked earlier on that of course what the court's concerned with here is these particular schemes and these particular decisions and so on, but the mechanics of this exercise are mechanics that would apply to any other scheme, and so it would be, the court needs to be mindful of the effects of that in terms of the legal outcome, and I say that because, just to go back to the way the point was put to me earlier on, it would not be, we say, appropriate for the court to say, well, let's say these are small numbers, therefore this doesn't matter. I'm paraphrasing in a rude and crude manner the way the point was put to me. One here isn't concerned with the numbers, one's concerned with the legal mechanics and the legal consequence of it, given the way this decision was reasoned and given the way the case is put on both sides. It's not said that, and it would have been a bad point anyway, the court can in effect sidestep all of this by saying, well, the Secretary of State's entitled to say this is all small. The Secretary of State doesn't say that, at least in relation to the fallback position.
If you were just, were you coming to an end?
I am coming towards an end, yes, my lord.
Right. Well, at some point, I just want to go back to a question that I asked you earlier on, which is to do with the regulations and the interaction between regulations 5 and 21.
Indeed.
As I understand it, your challenge to what's happened here is an assertion that the Secretary of State has not lawfully carried out his or her responsibilities under Regulation 21.
Yes.
That's right, isn't it?
Yes.
So the challenge is to the Regulation 21 exercise, which is at 26 of the materials bundle. And could you just focus in on what part of Regulation 21 you say has been disregarded or improperly applied?
Well, yes. So it is page 26.
It's page 26, Regulation 21.
Yes.
Yes.
So when considering whether, so that's the yes/no question, the Secretary of State must A, examine the environmental information.
Well, that's not an issue here.
That's not an issue,
There
no.
are pages and pages of
Pages
examples.
and pages of it, I understand that, but let me just slightly finish the point this way. The environmental information is only required to include the description bit. If I just go back to the language of Regulation 14 and the schedule, it doesn't in itself have to include the contextualisation, the percentage bit. So an ES could have simply given you the raw numbers in the tables without doing so. So this ES happened to go one step further, sensibly if you like, and indeed that's often the practice. But the description of the development doesn't necessarily tell you in and of itself how does this fare in the scheme of what's acceptable calculation. And that second stage is going to vary depending on what you're looking at. So if it's a noise impact, there'll be a noise threshold. If it's a biodiversity impact, it will be an impact measured by reference to the species. To use one of these cases, we're going to kill 10 bats, let me make it very simple, tells you nothing. Is that acceptable? What does 10 bats look like? To say we're going to produce this number of tons of carbon dioxide as a raw number tells you nothing. You have to contextualise it. So the next bit, B and C, reach a reasoned conclusion on the significant effects. That necessarily implies contextualising the description you've looked at. Yes. Reach a reasoned significant effects of development, take into account the examination, that's the data bit, and then integrate that into the decision as to whether to make the
what bit of that is your fire trained upon?
Well, it's the B and C bit. It's the reasoned conclusion on the significant effects.
Well, what are you coming out and saying? Are you saying that the Secretary of State did not reach a reasoned conclusion on the significant effects?
We're saying that what he necessarily needed to do in order to inform the weather decision was to understand whether these, sorry to use the weather word, these numbers in some context. Otherwise, these numbers are just numbers in the air. So the only way you can...
I mean, isn't really what you're having to... I mean, I'm asking you these questions because it seemed to me that your real complaint, if you have one, is that this was an irrational decision because, classic Wednesbury challenge on the basis that the Secretary of State should have seen that Dr. Boswell is right about this and that the figures that she was being presented with were not dependable in the terms of the combinations that were being made out of them, and that they should have been combined in a different way. Therefore, the decision that he reached was invalid because he should have spotted that there was this methodic flaw.
Well, methodic flaw, put it that way if one likes. There's you've got in the bundle the Law Society case, which talks about a want of logic.
Yeah,
you can put it in. You can use different phraseology. But what we say is that whatever is it were the underlying mechanic, whether it's a want of logic or however other words you want to use, what is legally missing here is other people have used this word, contextualisation of the raw numbers. And without that contextualisation, there simply hasn't been.
So that's where you keep coming back to, which is in your favour, that you keep expressing it in the same way, which is that effectively you say that in carrying out the responsibilities under Regulation 21.1, the detailed examination that you presented us with shows that the Secretary of State did not contextualise the data that she used to reach a conclusion. Is that really the attack?
Yes. I mean, we're substituting labels, but in the context of all that's gone before, that's not unhelpful.
But I'm coming back to the point that what is required under Section 21 is not the same as what's required under Regulation 5. Regulation 5 feeds into 21.
I think it's the other way around, maybe.
No, Regulation 5 is the environmental statement which is required to do the cumulative effect. And that feeds
I think
into...
my lord may mean Regulation 14, but I'm not. Regulation 5 is the EIA process.
Sorry, I do mean 14, and I apologise. So we're not here concerned with a challenge to the, as you've told us more than once, to the environmental statement. We're concerned with Regulation 21.
Because, and two reasons, we're not concerned directly with the ES. One is that the ES is only required to include a description of the development and its impacts. So a description could have just been the raw numbers. That's limb 1 of it. So whether it goes further or not is neither here nor the question. What matters is what the Secretary of State does. That's answer 1. Answer 2 is that would be a Blewett challenge. That would be a pure Blewett challenge. And you can, the point is you can have holes in the ES, see Mr. Justice Sullivan in Blewett, and that isn't the basis to say this is unlawful. What matters is what the decision maker does with that and all the other information, and the other information here included Dr. Boswell and all the rest of it. It also, as it happens, included information about carbon budgets that could be used in this way.
Thank you. That was my question.
My lord, if I just make one more moment. Lord, I'm grateful.
Can I just ask you to go back to the table that you took us to in the supplementary bundle at page 106? And I think your complaint was that the baseline do minimum included the other schemes.
Yes.
At 14.7.2, the existing scheme emissions, it says the baseline against which the proposed scheme has been compared is a do minimum scenario. Where does it say there, or is it in another bit that hasn't been copied, that this includes the other schemes?
So it's a very good question, my lord. This is the point that the judge, I think, refers to as being not immediately clear.
Yeah.
And it isn't immediately clear from those documents, and it emerges through the process. But we do get it from, we get it from the decision letters,
yeah.
And we also get it from the Secretary of State's response to the claim.
It's common ground there.
It's common ground. I think that's the best place to look at it. You can look at it, for example, in decision letter 3, which I didn't directly take you to, which is in tab 10. I think it is page 455. At 102. The traffic model is inherently cumulative because it contains data about. Does my lord see that?
Yeah.
And then second bullet, other proposed developments, including, in this case, this is scheme 3, scheme 1 and scheme 2.
Right. Thank you.
But my lord is right. It's not something that leaps off the page of the environmental statements.
I take it to be common ground not only that the other schemes taken into account were the other two of the trio were concerned with, but also the additional scheme being proposed by the Norwich City Council.
Indeed.
Right. So total of 4 schemes.
Well, and other things as well.
And others as well.
Indeed.
Which for present purposes we needn't concern ourselves with.
No. And as I say, we're all let's say stuck with the wrong word, but we're all working from their choice of other schemes.
Yes, I guess helpful perhaps somewhere to have a single page setting out how how the choice was formulated, or was it a reference to a map or list or whatever? But
from our purposes, my lord, it may be helpful. For our purposes, my lord, the result is what matters,
yeah.
and I think the result is.
Yeah.
However you get there, we see what the answer is.
On any view, all 3 of our schemes, plus the City Council scheme, were included
in DM and in DS in each case.
In each case, yeah. Thank you.
Sorry, no, not in each case. Not all 3. I misspoke. DM only includes the other 2 schemes in each case. DS includes all 3 schemes. So for DM for scheme 1,
yes,
doesn't include scheme 1. That's the definition of DM.
Of course, yes. Sorry, I understand.
Yeah. We went a bit too fast.
Sorry, you slightly. Can I just going back to that table again? Then at 106. So the baseline, the do minimum, includes the other schemes.
Exactly right.
And the do something, does that also include the other schemes?
Exactly right. So that the difference between DM and DS, the other way around, DS minus DM, is only this scheme, arithmetically.
Right.
That's why the judge is right to say what's compared against carbon budgets is only the impact of the scheme.
Yeah.
So you could have had a calculation to get to the result that, in a sense, has been achieved in the end. You could have just not gone through the DM and the DS. You could have just calculated a scheme-only figure, compared the scheme-only figure to carbon budgets, and you'd have got the percentages, the 0.004% and so on, and everything else on one reasoning, one logic, could have been left out of the calculation.
And you say that's not cumulative.
There's no cumulative assessment. What's done here is cumulative assessment is agreed needed and is said to be done, but it's done by using the figures in the way that... So it's not a case where it's said cumulative assessment doesn't apply, this is climate change. It's not said there are no cumulative impacts because there's no other related schemes. It says there are related schemes. They do have to be taken into account, and the Secretary of State signs it off on the basis, in each case, that they have been, quotes, taken into account, but in a way which means they come in and go out. See my Lord's question.
And the percentage for the scheme that we've got at 106, where is that actually set in the decision letter?
In the decision...
sorry, in the EXA.
It's set on 104 at 1488.
1488. Thank you.
So that's what you...
Yeah, and can I then just ask this final question, which is when the Secretary of State approves this, then we'll have, although we know you shouldn't just add up 0.004% and 0.002%, whatever it is, we'll have had at least the single effects of each schemes, which they can then see that.
No, because these are three separate decisions by three separate ministers on three separate
Yeah.
occasions. There's no point. Well, one can imagine a situation at which some decision maker, a minister or a Secretary of State, sits there with three lots of documents on the desk and says, I'm going to conduct my own cumulative assessment of these three schemes. And it's a very good question, if I may say so, my Lord. That never happens here. These are three separate ministers, each of whom is presented with what you've seen. So each scheme, although they're slightly in sequence, actually they could have been done on the same day, but by three separate people, each of whom only knows about the other schemes in terms of the numbers, what they've got. But at no point does any of them add together any of those numbers to make some combined figure to compare against carbon budgets.
Thank you. Sorry to ask so many questions.
No, they're very helpful questions, my Lord.
Thank you very much, Mr. Wolf. It's been most helpful.
I'm grateful.
Thank you.
I'm sorry, of course. 201.
Yes, Mr. Sir.
My Lords, can I just start by focusing on your Lordship's question a moment ago, namely what is the challenge in legal terms to the Secretary of State's decision? And as the judge below identified and your Lordship was exploring, it is indeed a rationality challenge, however dressed up, to the approach adopted by the Secretary of State to the assessment of the likely significant effects of these three projects. And that is how Regulation 21 is expressed. That's what's required of the Secretary of State. You will see from each of the decision letters, which you've not been taken to in their reasoning, save for a few paragraphs, that the Secretary of State reached a conclusion in respect of each of them. They would not have likely significant effects for the reasons given. But I'll come back to this in a moment. It is a bit disappointing, for example, in relation to one of the central propositions dealt with by the judge below, also you weren't taken to the paragraphs of the judgment where that reason is set out, that the judge below identified correctly that the Secretary of State explained why he was not going to carry out the assessment calculation that Dr. Boswell suggests has to be carried out. So, and I don't want to, I will come back to this, but you were taken a moment ago to the decision letter 2, I can pick it up there, in the context of, well, what was the Secretary of State's reasoning for adopting the approach the Secretary of State did, which is what the court should be concerned with, the rationality of that explanation. And you weren't taken to the rather lengthy explanation of precisely that issue. On page 429 of the core bundle, from 96, paragraphs 96 onwards. This, of course, is what the judge below was identifying. And the Secretary of State, far from ducking the issue, the difficult issue of climate change and cumulative impacts and how you assess them, and I'll come back to that in a moment, it's important, was tackling this very point. How do you go about, for the purposes of making an informed decision, an assessment of the effects of a project in relation to climate change, where you're dealing with an effect which is felt on a global level, distinct from other environmental effects. In those circumstances, what approach should the Secretary of State choose to adopt by way of evaluation in the assessment of likely significant effects, bearing in mind that one project will potentially accumulate with emissions generally, globally? And what's set out in paragraph 96, 97 onwards is a detailed explanation as to why an assessment against the carbon budgets does exactly the exercise which the Secretary of State considered rationally was an appropriate one, namely take account of not just a selected 3 or 4 projects or a local area, but all of the emissions that will occur nationally through the carbon budgets. They are expressed as carbon budgets, but there is a legal obligation to meet those budgets for carbon emissions from all sectors, not just roads, but all development. The net impact of all development in those periods will have to meet those budgets. And the Secretary of State explains that is why, for cumulative assessment purposes, it's appropriate to consider the scheme's impact against the cumulative impacts of all projects, not just road projects, but all projects in each of those carbon budgets. And indeed, as the judge pointed out below, and I will submit to your lordship, it's irrational in substance to do anything else. It's not just formalistic. It's a meaningless exercise. And what's been the essence of this challenge is something based around the rationality of that explanation. It is a surprising challenge, to say the least, because, as I'll show you and the judge referred to, but you haven't been taken to, it also reflects the expert view of the guidance by the Institute of Environmental Management Assessment. So it's a bold submission to suggest what the Secretary of State's done is irrational, where not only did the experts from National Highways propose it, the examining authority inspectors endorsed it, but it's actually the standard approach commended by the relevant, I say relevant, but one of the bodies that provides advice on how you carry out these assessments. That body, and I'll show you the guidance in a moment, makes it clear that there is an obvious danger in doing the exercise that Dr. Boswell was propounding, because it's inherently arbitrary, taking road projects limited to a particular geographical area or in a bundle or basket in order to assess cumulative impacts. It is not helping anyone. It doesn't tell you what the impacts are for the nation or for the or globally. It will likely, almost certainly likely, lead you into some sort of arbitrary and skewed assessment. You'll end up with a percentage based on selected projects within an area, but that doesn't tell you what the actual effects are on the climate, which is, of course, what this is concerned about. And can I just want to set that context. Can I just rewind a little bit in explaining my submissions why that's important? The environmental impact assessment is a process, as my learned friend pointed out, but as has been repeatedly emphasised in the courts, it's a tool for environmental decision-making, not an obstacle. It's intended to provide a process by which the Secretary of State can gather information and then make an assessment of the effects. It is, and you've been taken to the regulations themselves, important, two facets of them. First of all, as the cases make clear, including the Friends of the Earth case, it uses language which requires evaluation by the decision maker. It's not prescriptive. So, for example, understanding what information needs to be collated is an evaluative exercise for the decision maker, and understanding what exercise to undertake, what assessment you undertake of a cumulative assessment, is itself an evaluative exercise. People come up with different views. Dr. Boswell's come up with his view. The institutes come up with their view. It's for the Secretary of State to approach it in the way he or she thinks fit, based on that information. And the other facet of it, it is not prescriptive as to how one goes about assessing particular effects. And there's a very good reason for that. The environmental impact assessment, here the infrastructure regulations, are applicable to all environmental effects. They list them broadly speaking, such as climate and air, but they've got to cater for all situations. And it's fundamental that any effect, environmental effect, will require an approach which depends on the facts and circumstances. This is something that is alluded to by the Secretary of State and the Institute. But the classic, the standard, I call it standard, but the more common environmental effects are ones which can be and do have a cumulative effect locally or in an area. Noise, air quality, transport, or landscape, visual effects. The concept of cumulative effects will almost certainly, in those such situations, be a local cumulative effect. That locality may expand or reduce depending on the effect you're concerned with. But the concept of cumulative effects is ensuring that a project doesn't go ahead in isolation without thinking how it might combine in order to affect what's known as the receptor. That may be a grand term, but it can be a person in terms of noise. It can be a physical feature, such as a roundabout in terms of transport, where the volume of traffic may cause an effect on the receptor such that it becomes over-congested. All of those effects are, generally speaking, local. The curious feature of climate change, of course, and why the regulations require this exercise of evaluative judgment as to how to go about an assessment, is that it's very unusual in that it's not a cumulative effect that accumulates locally in any sense. It's a global impact. It doesn't even accumulate nationally. It has a global impact. Of course, one can't assess climate change by looking at the broader global picture in terms of all development, but the proxy for assessment of cumulative effects here necessarily is one that starts by reference to the carbon budgets and the net zero target. That's the only way one can assess how a development is going to impact globally, by looking at the contribution it will make to the UK's targets. And of course that is, as I pointed out, very different from another type of impact. And it's in that context I think it's important that the courts ask, well, how was it that in relation to the environmental statement, that for the purposes of the assessment there was reference to certain roads that were included in the environmental statement. It's important to understand that for the purposes of all of the environmental statements, certain base information has to be accumulated in order to inform all parts of the environmental statement. One of the things here, when you're assessing a road scheme, is to identify an affected road network, as it's known as, because that has different consequences for different parts of the environmental statement. Putting it very shortly, if you dual a small section of road, you may increase traffic, you may affect noise, but the limits of its effects will be governed by the affected road network to a material degree, the point at which you can say more traffic will come from there or here in this particular locality. And so for the purposes of an environmental statement as set out in the National Highways Guidance, one has to try and identify a traffic model, and that's usually produced in a region, to identify what traffic flows are and how they may be affected if you change the road scheme. And that will have consequences for modelling the air quality impacts, as you're measuring where the traffic will go, measuring the effects on congestion, and all of those local effects. The affected road network used for this scheme, and there were maps before the judge below. I believe there's some dispute between the claimants and the appellant and the second respondent as to whether this court should see those. I'm certainly content for the court to see the identification of the affected road network. But that is, in a standard process, is what goes into the environmental statement. And so it's unsurprising that in drawing up an environmental statement, National Highways has to settle on an affected road network to inform all facets of the environmental statement, particularly traffic modelling. That then has fed through into the climate change chapter, because you have a base model to work out what is the level of traffic that will be flowing in order to generate greenhouse gas emissions from that affected road network. But it's a fallacy to suggest that in itself dictates how you then assess the global cumulative effects of greenhouse gas emissions in considering the effect of allowing a scheme. The two is a false logic, because of course when one's coming to assess the receptor of greenhouse gases, it's, as I pointed out, the global effects. And one has to think about how then to go about that rather different exercise, which is precisely what the Secretary of State did. And so I hope that at least helps to underpin some important submissions I just want to make about the legal framework that the Secretary of State's operating under. There are two parts to it of critical relevance here: the Planning Act and the EIA regulations, the infrastructure regulations to which you've been taken to. So far as the Planning Act is concerned, my learned friend referred you to passages in the Friends of the Earth judgment in the Supreme Court. There is also in the bundle for the court a decision of Mr. Justice Holgate at first instance, which was subsequently upheld in the Court of Appeal, but the analysis of the reasons for the introduction of the Planning Act system in the Client Earth case, tab 10 of the bundle of authorities, and there's an explanation, detailed explanation of the Planning Act regime at paragraphs 32 to 4 and 48 to 52. And I won't take the court to it now, but the Friends of the Earth passages, I think my learned friend gave to the court, tab 11, paragraphs 19 to 38. The basic point is an acceleration of the process for development consent of national significance. And as part of that, the formulation of national policy statements, which are intended to set a policy approach to how to approach these nationally significant development projects. In this context, the national policy statement, which is identified by the judge in the judgment is the National Policy Statement for National Networks. That covers networks like road or rail and an approach to identifying them. And within that, it sets out a policy as to how to deal with climate change and the impacts of greenhouse gas emissions. And as recorded by the judge in the judgment at paragraph 19, page 86 of the core bundle, it's recognised that the point about individual projects unlikely to having an impact because of their levels of emissions are likely to be low. But it then goes on to deal with, of course, the government's overarching national carbon reduction strategy. This is in paragraph 19 of the judgment, paragraph 5.18, making the link with all of the other policy and legal obligations to address climate change and carbon increases from road development in order not to breach the overall carbon reduction principles. That forms part of the national policy statement, which isn't under challenge and can't be under challenge in any decision, because there's a separate judicial review route if you wish to challenge what the policy is. It therefore concludes the end of 5.18 of that statement: any increase in carbon emissions is not a reason to refuse development consent unless the increase in carbon emissions resulting from the proposed scheme are so significant that it would have a material impact on the ability. So that's the policy framework that's been established pursuant to the Planning Act. Just the reference to carbon reduction strategy that's referred to there, that is referring to a whole raft of other, I think my learned friend called it levers, but policies and ways in which the greenhouse gas reductions and the carbon reduction strategy will be met by the government in order to comply with the Climate Change Act. They are actually referred to by the Secretary of State in the decision letter and the examining authority. And what is identified is that whilst, of course, one can consider greenhouse gas emissions from a road scheme in terms of the users of the roads emitting emissions from the vehicles, the premise of that is that they're using emitting vehicles. Of course, one of the policies that forms part of the net zero strategy and various other documents is that there will be a gradual reduction towards non-emitting vehicles through processes of electrification. It's therefore completely wrong for my learned friend to say allowing a road scheme is a one-off event which triggers climate change emissions, which therefore you can't reverse. That's fundamentally not the case. Emissions will occur if you use petrol and diesel vehicles, and the extent to which their vehicles are dependent upon their design. But of course, there's a gradual carbon reduction strategy which the Secretary of State reflects and records in the decision letter, which takes one beyond 2050 into the future, beyond the carbon budgets, on which particular reliance is placed as a mechanism for allowing road schemes to go ahead. And in that respect, equally dealt with in the decision letter and the examining authority's analysis, we haven't spent any time on it. The need for these road schemes isn't to generate traffic per se, they're to relieve congestion, address safety concerns, and to allow other things to occur economically or otherwise, which have been identified as necessary as part of the national policy on allowing roads to occur. The impression my learned friend's given is building roads equals greenhouse gas emissions. Not so. It depends on your policies you apply in the future to cover what traffic passes on them, all of which is covered in the decision letter. So the Planning Act is an important context for these decisions. And before I break, the other important context is the environmental impact assessment regulations that I was identifying a moment ago. In addition to them requiring evaluative exercises and not being prescriptive, it is a basic, in my submission, fundamental that my learned friend is not able to articulate any identified defect in the environmental statement that was produced by the National Highways in this case. That's something that was expressly disavowed, because of course the environmental statement does provide a description as required of the effects of the scheme, as well as of course the effects of the affected road network in terms of greenhouse gas emissions through the do minimum calculations as well as the do something calculations. And so there's no challenge now to the adequacy of the environmental statement in identifying the relevant descriptions. That begs the question, what is the challenge? And my learned friend has now made it clear that in effect it's a challenge to what the Secretary of State has done with that information. And in that regard, there is absolutely nothing in the environmental assessment regulations which prescribes how the Secretary of State is required to use the information in the environmental statement. There is an
Regulation 21 is the only book of rules, as it were, for the Secretary of State in this aspect of a planning application.
Effectively, yes. And that's because what the object is to reach a reasoned conclusion on the likely significant effects. It's important to note they've got to be significant effects, not insignificant effects. And back to the Blewett case and the Friends of the Earth and the Supreme Court, reaching a reasoned conclusion and making a judgment about likely significant effects is the classic exercise in an evaluative judgment using the information that's presented to you. The one thing you will not find, you have not been taken to anywhere in these submissions, is the notion that the exercise Dr. Boswell was contending for, namely taking a percentage figure of certain road schemes as against the carbon budgets, is something that's required as a matter of law. And in my submission, it plainly is not required as a matter of law, and the Secretary of State, as I'll show you after the short adjournment, has explained, certainly rationally, I would go further and say entirely logically, but certainly rationally, why the approach has been adopted that was adopted. Is that a convenient moment?
That'd be a good moment. Thank you.
Eyes, if you're able to.